Good afternoon, ladies and gentlemen. Thank you for joining part one of a three-part series of NIADA's webinars. Today's was originally styled as a safeguards rule webinar, but in light of the FTC's March 13th warning letters to 97 dealerships regarding advertising transparency and potential violations of Section 5 of the FTC Act, we decided to split this up and start things off with a quick discussion from the FTC to provide a brief overview of the warning letters and advertising transparency, and to answer a few questions that we have prepared in advance based on some feedback that we have received from our members. So allow me to introduce Chris Mufarrige. He is the director of the Federal Trade Commission's Bureau of Consumer Protection. He is an experienced consumer protection lawyer. He served in the first Trump administration as a senior advisor to both the director and the deputy director of the CFPB, advising on enforcement, rulemaking, supervisory exams related to the country's largest banks and non-bank financial institutions. Prior to assuming his current role, Director Mufarrige was then FTC Commissioner Melissa Holyoke's chief of staff and attorney advisor. He also worked in private law firms and as an in-house lawyer. I think it's important to note another noteworthy element of his professional experience, which I recently learned, is his time working in his family's auto dealership. So Director Mufarrige brings a practical understanding of how car dealerships operate to his work at the FTC. Director Mufarrige, the floor is yours with our gratitude.
Thanks, Patrick, and thanks to NIADA for having me here today. It's a real privilege to be here to get to speak to all of you. I'm the bureau director of the Bureau of Consumer Protection at the FTC, and I guide all of the FTC's enforcement efforts under the consumer protection laws. One issue that is central to our positive agenda here at the agency and for the administration more broadly is pricing transparency. And I know some of you have seen these efforts reflected in our recent warning letters to 97 dealers. In response to the letters, I understand that folks have a number of questions, and I want folks to understand those questions are very important to me, and they're very important to the chairman, which is why I'm here today. In addition to engaging with you all in this webinar, we intend to issue FAQs in the coming months that are going to answer some of the more nuanced questions that we've been receiving on these particular issues. So I'm hopeful that this engagement will hopefully provide some guidance and improve folks' understanding about what it is that we're trying to accomplish with this initiative. And with that, Patrick, I'll turn it back over to you.
Thank you, sir. I do have a few questions, and let me just start off by saying I think I speak on behalf of everybody who's on this call, how grateful we are here that there will be clarifying FAQs on such an important matter. So thank you in advance to you and your staff for agreeing to do that. That, in fact, was one of the topics I wanted to address. But let me start off by just noting that we've received a lot of positive feedback regarding these letters. Our members embrace this type of market conduct policing. We believe that, frankly, the market works best when you have a level and competitive playing field, and this type of policing of market conduct is exactly how we get there. But one question that we have received from a number of dealers, Director Mufarrige, is, does the FTC have some sort of a formal process through which, if a dealer were to see some market misconduct within their community and their industry, is there an avenue through which that can be shared with the FTC for a potential follow-up?
Sure. Yeah. So there are multiple avenues. Obviously, they can work with NIADA to get those complaints to us. You can reach out directly to our staff. You can also report. You can also report problems on reportfraud.ftc.gov.
Fantastic. Thank you very much. And we appreciate allowing NIADA to play a conduit role as appropriate in that particular fashion. Another question that we've received is it's regarding federal versus state laws. And we're curious if there's conflict between a discrete law at New Jersey, if you will, regarding a particular fee that under the state law may not need to be disclosed as the out-the-door price. If you could just clarify to the best of your ability, in those particular instances, is it the FTC's view that those state laws are preempted?
Sure. So I think first it's important to emphasize that I don't believe that there are really many instances of any conflict between federal and state law. I think for the most I've seen there are perhaps some nuanced examples or fact patterns that may present some tension. But to answer your question directly, if federal law conflicts with state law, then federal law wins. And in this instance, the expectation under federal law is that the total price that's advertised reflects all mandatory fees that a consumer will have to pay in order to purchase the vehicle.
Understood. Thank you for that clarification. That's important to everybody on the call. Let me just switch to advertising transparency, which of course is the crux of the issue. If a dealer is using a third-party platform, and I won't name any, there's plenty out there, but if they are using one of those, who is responsible for ensuring that the price reflected on that particular platform is accurate, specifically in cases where the platform is at fault for the advertising error, whether it's a fat fingering issue or a failure to update the platform, any other scenario that is really
Right.
on their end rather than the dealer?
Sure. So, at bottom, the crucial question is, who's in control of the material that's presented to the consumer. So if it's the case that the dealer is the one that's inputting the information and inputs information that's incorrect or misleading, obviously it's the dealer that's liable. If it's the third party platform that interposes or does something that to contribute to or to create the misleading impression, then it would be the third party platform.
Understood. Thank you for that clarification. Along those lines, for recently sold vehicles, does the FTC recognize any sort of a grace period between the sales date and the point at which the vehicle is no longer advertised as available before the dealership is considered to be out of compliance? In other words, if there's a lull period between a car rolling off the lot to a buyer and that car being removed from whether it's the dealer's website or a third-party platform's website, if there's some type of a grace period that you recognize, I think it would be important for us to know.
Yeah, I mean, I like from my perspective, my own experience here, I mean, my own experience was that if a car was sold, we would take the car down off of the website, quickly. And I think the idea there is that, I mean, I don't really see a scenario where if you sell a car on on a Monday, there it really should be the case by either that day or the next day, the car should come down.
Okay, I appreciate that. And that kind of gets to the question earlier about control and using the third parties. And if a dealer takes the appropriate steps and measures to contact TrueCars or whatever the case may be to say this vehicle should no longer be advertised, the control mechanism, in your opinion, would fall with, since there's a paper trail going to that platform, the onus and the responsibility would lie at that point with the vendor rather than the dealer, since they've taken the appropriate steps to ensure communication with that particular platform that this car is no longer available and should no longer be advertised.
Yeah, I've never experienced advertising on that website. In my experience, the dealer's in complete control over what gets uploaded on the third-party website. So, I mean, obviously, all these things are fact specific, but in my experience, it's always the case that the dealer could just go on and take a listing off. But if there's a different set of facts out there with regard to a specific type of third party, obviously we would be we would look at those particular facts to understand who's in control.
Thank you. Yeah, and we're just being very conservative in terms of making sure that we're doing right by what's required under the law, hence my follow-up question. And then the last question I have for you, and it's one that certainly you received over the past couple of weeks, it's regarding doc fees. And I know there's been a lot of intrigue about the application of doc fees when it comes to the total price. And it's our understanding that, of course, that only mandated fees may be excluded from the advertised price, the sales tax, title, registration. Does that mean that the FTC expects doc fees should be included in the advertised price? Because again, there is some confusion depending on who you ask.
Yeah, the question is unequivocally yes. It's a fee that dealers require consumers to pay. It should be reflected in the total price, and that principle governs regardless of the name of the fee that the dealer gives to it, whether it's a doc fee, a service fee, a paperwork fee. These are all these are fees that the dealer is not required to make the consumer pay, and that's the key.
Well, this has been great, sir. And I just want to reiterate our gratitude on behalf of NIADA's 13,000 members, how delighted we are to hear that you will be following up with some clarifying FAQs. I think those will be well received. And to the extent we can serve as a resource as appropriate, please feel free to reach out through your staff, and we'd be happy to provide anything that we can to make that a good source and reference. So thank you very much for joining us. It means a lot to us.
Yeah, thanks, Patrick, for having me. I really appreciate it.
Thank you.
Take care.